Okay. So here also the same question. What is cognizable? What is non-cognizable offenses is very important topic. So those things you can get in the first schedule of the CrPC. Okay. Cognizable, non-cognizable, bailable, non-bailable, and where the case can be tried. Okay. This is the classification. Okay. Cognizable, what non-cognizable, and we will not discuss much in depth today because already we have discussed about in length in the last time. Okay. I'll see if, okay, cognizable is more than 3 years imprisonment. Non-cognizable is less than 3 years imprisonment. Police can register FIR and arrest without magistrate permission is the basic thing in cognizable offense, and all other things they need a magistrate permission to arrest the person or register an FIR also if it is a non-cognizable offense. Okay. Bailable offense is now again, because I am talking about the schedule, first schedule, bailable offense is accused has a right to bail. Non-bailable offense, bail is not a right. He has to go to the court, file a bail petition, and it is through court he has to get the bail. Okay, it is for serious offenses, it is non-bailable. Again, the bailable, non-bailable is also in the first schedule only. Okay, and who will try what cases also is in the first schedule only. Summons case, warrant case, sessions case. Okay, so there is a overlapping. Okay, all sessions cases are also warrant cases only. But not all warrant cases are sessions cases because some warrant cases are tried in magistrate courts also. But in sessions cases, it all will be warrant cases only because only serious offenses come to sessions courts and all sessions cases will be tried under warrant type only. But it will be much serious procedure will be followed in sessions cases. The warrant will be issued, but procedure will be little bit more complicated than warrant case. Summon case is very less complex. It is very simple. So here you can see criminal trespass and defamation is also summon case, but you were talking about summary case. That is the reason I was confused actually. So the question may be wrong. If the question is wrong, that question will be removed actually. Okay. 1 minute. Huh? So this is okay. This is not, I mean, not important for our this today's session. Okay, this is useful for our regular practice. Are you able to see the screen?
Yes, sir.
Yes, sir. We can able to see.
I am trying to open some other things actually. I gave you that flow chart, right?
Yes, sir. We have the flow chart.
Yes. So from the flow chart, I mean, you can open in the mobile so that it will be easy. Just I'm opening my flow chart actually. That is the only thing. Okay. So it will be easy for you to understand because what I'm taking here is from where serious, I mean, where actually the real practice starts. Okay, for an advocate, it is from section 154 onwards. Okay, this is from section 154 onwards, where actual practice of an advocate starts. Other things are also important, but here is actually what happens in a criminal case. It is from section 154. Okay. So I'll talk about section 154. Then in between, we'll try to clarify other things. Okay, so that it will be easy for you to understand. Where, I mean, we'll go back again to arrest where we stop in the last session. So first, any criminal case starts from a commission of a crime. Okay, commission of the crime, then the information is given to police or a complaint to magistrate. So here you have to remember one thing. When a person go and inform the police about commission of any crime, it is called information, not a complaint. Okay, anybody, even though victim is giving a information, it is called information. We call it complaint for our convenience. But in law language, in CrPC language, let us talk BNSS language, it is the information to the police. Okay, complaint will be given only to the magistrate. Okay, so if police are not taking your information, or they are not doing any, they are not acting on your information, then you can go and complain it directly to the magistrate. Okay, so there are two options for anybody to start any criminal case, that is from information to police or complaint to the magistrate. That is the first stage. So once we'll go to the police, once it is with the police, police will check what is the type of the offense, whether it is a cognizable or it is a non-cognizable. Okay, if it is a cognizable, FIR is registered and they can proceed to arrest the person without any court permission. Okay, if it is a non-cognizable offense, they will go to the court, take permission of the court, then only they will register. If arrest is to be made, they will issue a warrant. Magistrate should issue a warrant for arrest. They cannot go and arrest without permission of the court if it is a non-cognizable offense. Okay, then once FIR is filed, FIR is registered, then investigation starts. Okay, police will start investigation. In cognizable, it is started immediately. After investigation is completed, police will submit a report. Okay, police will submit a report. Here there is a confusion. Okay, police report, there is a confusion. Police report is only one type actually as per CrPC. CrPC will not mention anywhere that there are two types of reports, that is charge sheet is one report, closure report is another report. Actually, I report closure report and charge sheet is there. Here I mentioned, but in CrPC, it is only one report. It is called police report under section 173. Okay, police report is completion of the investigation. Okay, once the investigation is completed, they have to mention whether offense is committed and they are having enough evidence. If they are having evidence that the person has committed that offense, they will file a charge sheet. If they don't have enough evidence or they don't have any more, they cannot go further in that investigation against that particular person, then they will file a closure report that no particular evidence is found against this person. So they will file a closure report in the court. So both are called police report or completion report. Okay, it is two-way. When the charge is framed, charges are fixed, it is called charge sheet. And if there are no charges, it is called closure report. It is purely a judicial practice. It is not there in CrPC. Okay, charge sheet and closure report are not in CrPC. They call it only police report in section 173. Okay, it is over the period of judicial development. Okay, if there is evidence, enough evidence, then only they will file the charge sheet, or else they will straight away go and file the closure report. A magistrate will do some due process. Then he will close that FIR and the case is dismissed. Okay, then closure report then will not go any further because there is no process once the case is closed. Here, once the charge sheet is filed, then the trial will begin. Okay, charge sheet is filed. They can see first offense is committed because here we are coming from the FIR stage, right? So in preliminary stages only they can arrest. He can go for the bail before charge sheet and even after charge sheet also they can go for the bail and they have to give sureties. Most of the cases, even if arrest is not made, when the accused is presented in the court, if there is a serious charges, even for less serious charges also, the court may ask to produce sureties. Okay. After the surety, then the trial starts. Again, the trial starts based on the offense committed. All cases are first put in magistrate court only. Okay. Magistrate court will see what are the offenses. Okay. If they are serious offenses, then he will commit that. Remember this word. Magistrate will commit that particular case to the sessions court. Okay. It is called committed to the sessions court. Okay. There is one sessions judge is there. Session judge, then he is having some administrative powers. See, magistrate court, there are specific jurisdiction based on the territory. There can be one magistrate court for one police station, two police stations, 5 police stations, depending on the area, crimes, all those things, various factors. There will be magistrate court only based on the jurisdiction territory. But session court, of course, there is a sessions court for one district or 2 districts, depending on the area again. But there can be 5, 6 sessions court, but it is not based on the territory. Sessions court, the sessions judge, because of his administrative powers, he will make over based on the workload of each sessions court. He will, okay, this particular case is made over to court number 2, sessions court number 2. This particular is made over to sessions court number 3, 4, 5, whatever is based on the case load, and there are some specific like POCSO and all those things he will assign to those specific courts are there. Otherwise, they will be assigned to specific sessions court. Sessions court is where the punishment is about 7 years. Less than 7 years, magistrate, first class magistrate can handle. Chief judicial magistrate will do the trial for less than 7 years punishments. Okay. So in sessions court, more than 7 years, it will be given to sessions courts. Okay. Are you able to get what I'm talking? So once it is in the court, then the charges are framed. Framing of charges. Framing of charges is nothing but based on the charge sheet. They will say so and so Ramaya, son of Somaya, he has committed crime under section 302 of IPC. So you are these are the charges framed against you. Okay. So then once the charges are framed, the person can plead guilty or not plead guilty. Plead guilty, then say I have committed the crime, is plead guilty. Okay, non-plead guilty is no, I haven't committed the crime, is not plead guilty. Okay, so if he pleads guilty that he has committed the crime, then the conviction is made and punishment is awarded there itself. Okay, when not pleaded guilty, then regular trial starts. Prosecution will examine, then defense will cross-examine, they will produce their evidences, they will bring their witnesses. Okay, all those things, documents, whatever documents are there, they will present. Then there will be final arguments. Then judgment will be there, conviction, acquittal, appeal, revision, execution. All those things are all covered under CrPC. Okay, so this chart I have given, it will be easy. Same thing if it is also in complaint to the magistrate. If it is a serious crime, they will direct to police to register. If it is non-serious crime, they will start like check bones case or some defamation case. He will start the inquiry. He will ask he will see the evidence produced. If he feels comfortable after speaking to the complainant, and the evidence he has submitted, he will register the case. Then it will be someone's case, not so serious case. Someone's case, it will be summons will be issued to the accused. There will be examination, plead guilty, not plead guilty, trial. But here, examination and cross-examination are much simpler compared to warrant cases. See here, these are all warrant cases. Okay, here it is not warrant cases. FIR is not registered. So someone's cases, it will be less punishment. then arguments, all those things will be there from here. So I have shared that flow chart. You can look into that flow chart. Okay. You got it? Any doubts, you can ask me. So why I told, why I gave that chart sheet, because I want you to understand the process so that it will be easy for you to go through, understand the previous steps also. Because when I am talking about cognizable offense, section 41 says about arrest. Okay. So when I am talking about arrest, I have to talk about cognizable, when the police will do that arrest, all those things will come after section. Okay. So that is the reason I thought I'll just, before that itself, I'll come back and I'll talk about those steps in the crime, so that it will be easy how come crime is committed. So it will be, we will go back again to section 41. Okay, where if you are having your Bayrak books, you can open Bayrak books. So section 41 is very important. These are 20 sections under this chapter. Arrest is the topic. Okay, under arrest it is around 20 sections are there approximately, and all questions are from Bayrak Act only. It is very important, 41 to 60. Okay. So when police may arrest without warrant, that is cognizable. Okay. Notice of appearance before police officer. Okay. These are all purely based on Bayrak Acts only. You will not get any questions. There are no concepts in this one. Okay. But when they ask about cognizable, when they ask about non-cognizable, that is the reason we refer to that first schedule. Okay, from first schedule, you will identify what is cognizable offense, what is not cognizable offense. So you can relate that to arrest. When police can arrest, when police cannot arrest directly. Okay, so section 41, it starts. There are subsections in 41, 41A, B, C, D. And in A also there are further classifications. Okay, where police can arrest. Okay, where police can arrest. Police officer has wide powers. You can open that. If you are having the Bayrak Act, it will be easy, so that I will be reading from the Bayrak Act directly. Any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offense. So, if any person commits a offense which is cognizable in front of him, he can arrest immediately. Okay. Against a reasonable complaint has been made or credible information has been received on a he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years. That is, also he can arrest. Okay, there are important subsections. They may ask questions about from here. The police officer has reason to believe on basis of such complaint information of suspicion that such person has committed the said offense. He can arrest in that time also. Okay. Who has proclaimed as an offender. This is another important point. Who has been proclaimed of an offender either under the code or by order of the state government. We will talk about proclamation in next few couple of chapters. Okay. Proclamation is under section 82, where court proclaim any offender who is not traceable, who is not appearing to the court, and they will attach their properties. Or there is a lot of procedure in proclamation also. So if police finds any person who is declared as a proclaimed offender, he can arrest directly also for such person. Okay. Then 41A, this is very important. If it is a non-cognizable offense, the police officer has to give a notice to the person to appear before him for investigation. He cannot directly arrest. If he is not appearing, then he can arrest. 41A is notice. Okay. There is another important point. The section is 41B. I think just I'll go through that one. I am unable to find that one. Notice of. Okay, in the 41 itself, you can find right of the person to meet an advocate of his choice during the interrogation and procedure of is also given. So who can arrest, what is the procedure, identification of name, all those things are there in the Bail Act only. So the important is, see, you will get a separate question, arrest by a person. That is okay. That is section 43. Okay. Arrest by a private person and procedure on such arrest. Private person can arrest. I mean, I can arrest, you can arrest, even though we are not police officers. Private person is also having sometimes powers to arrest a person. Okay. When a private person can arrest, a private person can arrest only in two situations. Any person who commits a non-bailable and cognizable offense in his presence. Okay, he can arrest. So you see a person committing a very serious offense like attacking somebody with a knife or trying to steal something, you can catch hold of that person, you can bring him to the police station, or you can arrest, catch hold of him, call the police, you can do that. And here again, any person who is proclaimed offender. Okay, if the person is a proclaimed offender also, you can arrest him. You need not be a police officer. Okay, even a private person can arrest. So arrest, how it is made in given in section 46. So basically this is as I told, Bail Act based questions. You can go through this Bail Act itself. The question will be asked how the arrest is made according to section 44, 43. Who can arrest? Private person, police officer. Such questions are only asked from this entire till 60. But anyhow, arrest procedure is there. I'll just go through the Bail Act index itself for this specific thing so that we can cover more topics under this. Okay. Arrest by magistrate, protection of members of the armed forces from arrest. Okay, there is separate section under 45 where protection is given for armed forces. There is a specific procedure how to arrest an armed forces. And section 46 says how to make an arrest. Okay, section 47 says search of place entered by person sought to be arrested. So when you go and arrest, try to arrest a person, how to search that place is also given there. Okay, so no unnecessary restraint, power of to seize offensive weapons can be seized. All those things are given from 41 to 60. Then next comes process to compel appearance. See here, we were talking about summons, warrants. Okay, summons is given to the person. That is the reason all those things are related here. This is a concept-based question, what we spoke in the initial definition parts. Okay, what is summon, what is warrant? So process to compel appearance, it is from summons. Okay, summons, how it is served is in section 62. Summons is served, normally it is signed by the section officer or magistrate in some cases. Okay, summons is in writing. It is directed to the person to whom the court want to be to appear in the court. It can be the accused or it can be a witness. Summons will be given in his name only. Okay, so summons can be given to the police officer or it can be directly sent to the through a court officer also. May not be through police. And in summary trial like check bounce cases, it is sent through registered post in most cases. Okay, service of summons on corporate bodies. Service whom when person someone cannot be found. Okay, when a person cannot be found, this is another important. So 64 says when a person cannot be found, how summons are served. Okay, what you will do. This is important. You have to read this thing, section 64. So when a person is cannot be found, what you will do. So you have to, I'll read this one. Where the person summoned cannot by the excess of due diligence be found, the summons may be served by leaving one of the duplicate for him with some adult male member of his family. See, this is internally they will ask the question here. Okay, with whom he will live under section 64. Adult male member of the family, okay, residing with him, and the person with whom the summons is left shall, if so required by serving officer, sign a receipt thereafter on the back of the other duplicate. A servant is not a member, explanation, a servant is not member of the family within the meaning of this section. Okay. So here it should be given to any male of eldest male person in the family and take his signature on the duplicate copy. So when the court officer is serving the summons, he will go there personally through Nazareth. Normally they will be serving. So they will go personally, they will serve the summons and they will take the acknowledgement on the duplicate copy that the summons is served. When the summons is served through registered post, acknowledgement is the proof of delivery. And postal track is also, we treat it as a proof of delivery of the summons. Okay. When the summons served is, after service of the summons, when the person is not appearing, then NBW is issued, non-bailable warrant is issued. So warrant will come there in the next level. Okay. Warrant of arrest. So from section 70 to till 81, it is warrant of arrest. Okay. So warrant will be issued through police. So it is a direction to the police to produce that person in the court on specific date. Or if it is NBW, police can bring him and he can apply for the bail. If it is NBW, normally that procedure is not followed. If it is non-bailable warrant in a private case, police will never bother. If it is in a police case, if it is serious offense, they will go and arrest that person and produce him in the court. Then he can apply for regular bail or they will send him to the remand depending on the crime. Okay. So warrant is always directed to the police officer to specific police station. So form of warrant of arrest, it is in writing. It will be given to the police officer. Power to direct security to be taken. So once if they say police, see in warrant, some cases the directions will be there. Police can, once the warrant is issued, they will arrest and give station bail. Okay, in few cases they will give the station bail there itself, or they will take personal surety and leave him there itself. There are two types of bails. One station bail is there. One personal bond is there. So they can leave on personal bond, or they can take some deposit. They have to deposit some money, like what we take from courts, FD from societies, or a DD is given, or any bank deposit is also given in the police station. If police is not having power to give bail, he will be produced in the court. Court may send him to the remand, or court may give bail. Okay, after when bail, but here in this warrant, when it is produced before magistrate, bail petition is mandatory. We have to file a bail petition. Okay, without bail petition, bail is not given in the court. But if it is police bail, police can give the bail on their own or personal bond. They can release a person depending on the crime. And if the police are having power, if it is a less serious crime, they can release the person on their own, taking the procedures. Okay, so then section 82 onwards, it is proclamation and attachment. So when the person is not traceable, when the person is absconding, then the court will give a proclamation. They will post on the wall of the offender that this person is declared as a proclaimed offender. Proclamation, once the proclamation is declared, any person can arrest that person. Police officer, either a private person also can arrest that person. So even after proclamation is declared, then the police can attach the property with the court permission. They will give the list of the properties. If they can identify any properties, they will give that list of the properties to the magistrate can attach those properties of the proclaimed offenders. Even in private complaints, if the offender is declared as a proclaimed offender, attachment can be sought. Okay, under this thing. Okay. See, first what happens, there will be, see, once the offender is declared as a proclaimed offender, initially they might have given some sureties, some bonds are given once, because when the offense is committed in the initial stages, from initial stages, if he is absconding, that is different story. But he has appeared and then he is absconding. So initial stages, they will give a surety bond, right? So first that surety bond is taken over by the court. Okay, first notice is also given to the sureties. Okay, if the surety is also not appeared, the court will take that amount. Okay, then they will attach the properties also. Okay, the next step. Then chapter 7, process to compel the production of things. I mean, it is not a very interesting, I mean, important topic for AIBE. So you can leave this chapter 7. Okay, but since anyhow, if there are questions from BEAR Act, you can answer. So even for concept wise, process to compel the production of things is also not important. Okay, reciprocal arrangements for assistance in certain matters and procedures for attachment and forfeiture of property is also not important. Never they asked any questions for AIBE from this security for keeping the peace and for good behavior. This is also not important for AIB, and this is also not important in our regular procedure, criminal process, steps by steps, what we have understood. It is also not important there. Maintenance of public order and tranquility. They may ask some questions here from the BEAR Act. 1 or 2 questions, 144 section related questions they may ask. Okay. So here, maintainability of public order and tranquility, most of the things is for executive magistrate related questions. So they may ask 1 or 2 questions in 5 years they have asked. Or else that this chapter is also not important. Okay. Next chapter, preventive action of the police. This is important. You have to read police to prevent cognizable offenses. That is important. They may, I mean, BEAR Act related questions. Information of design to commit cognizable offense. Police has to take action under section 150. Arrest to prevent commission of any cognizable offense. Section 151. Prevent to arrest. They make lot of people, when politicians they do, when they want to go out for dharna. So once under 161 only, preventive to commission of cognizable offense. They lot of preventive arrests are made here. Okay, prevention of injury to public property, even that also they can do preventive arrest, because when they are going on dharna, they may try to damage some public property. So on that basis, they will arrest. So this is police discretionary powers. Okay, preventive arrest. Okay, they mostly they do house arrest, or if there is a serious element, they bring them and put it in the police station, and evening they leave them normally. Okay, so they don't produce in the court if it is a preventive arrest. Normally they will leave in the evening once the duration is over. If it is some serious thing, they may continue it for after permission of the magistrate if they want to continue with that. Even house arrest also, if it is for more than 6 hours, 8 hours, or 24 hours, they have to inform the magistrate and they have to take permission for those things. A lot of politicians, they do a house arrest for more than 2 days. Okay, if it is more than 24 hours, it is illegal arrest technically. Even if the person is taken under detention, if the detention should not exceed beyond 24 hours, he should be produced within 24 hours before the magistrate. Magistrate can send him to the remand, or he can give it to police custody. It is the discretion of the magistrate. Okay. Now, the actually compulsory questions are from chapter 12 onwards. Okay. So from chapter 12 to almost chapter chapter 21, all are important chapters. Chapter 12 to chapter 21 are important chapters. So that is the reason I have taken that. If you want, I'll show that again. So I'll show that if it is still, yeah, it is still say there. I'll show that the flow chart again. This is not the one. This. It is here. Okay, so it is actually, that's what I told. It starts from section 154, information to police, that is commission of crime. Okay, cognizable crime. Information of non-cognizable crime is section 155. 154 is information of non-cognizable. So if it is cognizable crime, it is under 154. Immediately they will file an FIR and they will go ahead. If it is information of non-cognizable offense, they will file non-cognizable offense separately. They will write a report and they will submit it to the magistrate. If magistrate order, then they will file the FIR. Okay. So police officers, they can start investigation immediately under section 156 if it is a cognizable case. Okay. Then section 157 says how to proceed in the investigation, and section 158 says how report is submitted. Okay, preliminary inquiries, and there will be, see, even before arresting the person, if it is a cognizable arrest, they will give a preliminary report to the magistrate. Okay, along with the FIR, when they are arresting, they will produce before the magistrate. Magistrate straight away will not take any action if there is no document. So, if along with the FIR, they will submit some basic information along with the basic evidences, complaint, and who are the preliminary inquiry, what they have done. Those things they will submit along with the FIR. Okay. So along with that FIR, then based on the seriousness of the offense, the magistrate may give him to the custody, police custody, or send him to the remand. Okay. Then after that, see, basically here what I'm saying it is, if you can file bail petition then and there itself, if it is through regular this thing, but normally police produce in the evening, so they will be sent to the custody or remand. Next day you can file a bail petition. If the magistrate allows, bail is granted. If the magistrate denies, you have to file repeatedly bail petition, or you have to go to sessions court, you have to go to higher courts for bail. Okay. So once the offense is committed, then what is the procedure, like medical examination, search by police officer, all those procedures are to be followed. Then this particular person should be produced in the territorial jurisdiction, magistrate jurisdiction. They cannot just go and produce in any court. Okay. So what is the territory of that magistrate? Section 177 says ordinary place of inquiry and trial, place of inquiry and trial. Okay, see, inquiry and trial. Inquiry and trial. I want to give a clarification here. Investigation is done by police. Okay, inquiry is done by magistrate. Okay, inquiry is nothing but asking some basic questions. That is inquiry. There is no in-depth. So, entire investigation. So, court will never do investigation. Understand this. Court will never do investigation. Court will only do inquiry and trial. Investigation is only by police. Police cannot do any inquiry. Police cannot do any trial. Okay. This is important. So in that particular jurisdiction, which magistrate court it comes, that magistrate is having power to do inquiry and to trial only. No other magistrate will have that one. But if it is crime where it is some session where the trial should be done by session court, he will commit that case to sessions court. His jurisdiction is not there to try any case where the punishment is beyond 7 years. Okay, earlier there are there are two types of sessions courts, magistrate courts, metropolitan magistrate or judicial magistrate, chief judicial magistrate. Judicial magistrate is having only power to try cases up to 3 years punishment. Chief judicial magistrate can try cases up to 7 years. So chief judicial magistrate can try cases beyond 7 years then it is committed to the sessions court. Okay, based on the crime. So all the people, I mean, arrested people will be brought to Chief Judicial Magistrate only. Okay, Chief Judicial Magistrate, even Judicial Magistrate is also first class magistrate, but they will be produced in Chief Judicial Magistrate courts only. Chief Judicial Magistrate, because less than 3 years, police will leave them. 41A. So when arrest is made, normally it is above 3 years crimes only arrest is made. Cognizable offense, right? What I am talking about, cognizable offense. So cognizable offense is above 3 years. So arrest is made. So they will be produced before Chief Judicial Magistrate only, not Judicial Magistrate. So Judicial Magistrate is having powers to try cases where the punishment is less than 3 years. So less than 3 years, police normally it is a bailable offense in most of the cases. 41A notice is enough in those cases. So police will give 41A notices and they will send them away and they will issue summons to them. It is summon trial in judicial magistrate cases in most of the things. Okay, it is summons trials only. Majority cases, what I am talking. Okay, 1 or 2 instances it is different, but majority cases it is because warrant cases more than 2 years is warrant case actually. So, but in most cases it is summons cases only in magistrate, judicial magistrate cases. Are you able to understand why I am trying to do it faster? Because I want to cover more. Okay, then once it is based on this territory, it is committed to, it is done in the, I mean, charges are framed. The charges, okay, see, what is charge? That is very important, interesting thing. Okay, the charge we were talking about chapter 17. Okay, charge is nothing but an offense. Okay, in civil cases, issues are framed. Understand the difference. In civil cases, issues are framed. In criminal cases, charges are framed. Okay, so charges are framed based on the information given in the charge sheet. Okay, so based on the information, the charge sheet charges are framed. After charge is framed, the trial will start. Okay, so it is what are the offenses committed as see, charges is nothing to do with CPC, it is IPC. The offenses are from the IPC or BNS. So 302, 306, lot of sections under 314, 325, the various sections you can put IPC sections. Then the magistrate will frame the charges, reading over these things and whether there is enough evidence, and if there are 1 or 2 sections can be removed, he will remove those sections and only include those sections in the when he is framing the charges under section so and so, so and so, so and so, charge is framed. It is charge is nothing but list of offenses he has committed as per IPC. Okay, the offense under IPC, that is the so charge sheet is also list of offense. These are the offenses committed under so and so, so and so, with the details. All those offense details will give. He'll give explanation. All those things also, but charge framing of charges, all details are not given. Just under section so and so, so and so, you have committed so and so crime, so you are charged. Simple. Okay. So what are the things included? Statement of specific offense, particular place, time, what is the thing, law and sections violated. Okay, it should be in simple, very clear language, which can be understood by the accused also. And it should be, it will be signed by the magistrate, presiding officer. Okay, if it is whoever may be the, if it is presiding officer, why I'm saying not magistrate, because charges are framed in the sessions court or the magistrate court based on the thing. Okay, so the magistrate or the judge will sign that after framing the charges. He will explain to the, these are the charges we are framing. You will be tried on these offenses, on these charges. So then the trial begins. Okay, once the charges are framed, he can plead guilty, or he will not plead guilty. Not plead guilty, no, I didn't commit that offenses. Then the regular trials start. Prosecution will put his evidences. He will bring his witnesses. There will be chief examination. Okay. Then there will be cross examination. Okay. So here again, chapter 17 says the trial before the court of session. How the once it is, see, here we are having two things, right? Magistrate and session. So if it is trial to be done in the court of session, chapter 18 from section 225 to 229, they give the procedure how the sessions court should go ahead with this trial. Okay. So framing of charges, everything will come. If plead guilty, not plead guilty, then evidences, probable, acquittal, arguments, all those things will be there. Everything will be similar in warrant cases by magistrate also. So it is from section 248 to 243. The question can be asked. So under summary, sessions trial, what are the sections from which section to which section? 225 to 237, 240 to 250. Such questions are also asked in the AIBE examination. So trial of a warrant cases by magistrate is from section 238. Okay. So then till 250. Okay. Warrant cases, about warrant cases. So in warrant cases also, it is instituted on police report and instituted on a private also, other than police report. Okay. That is private complaint. So private complaint, if say they ask what is the procedure followed in a warrant case when it is instituted otherwise than a police report. So it is from section 244 to 247. Okay, conclusion of trial, then trial of summons by magistrate case. All cases are tried by magistrate until unless it is a punishment where the punishment is more than 7 years. Okay. So summons case, it is much simpler procedure. Summons case, the procedure is given from sections 251 to 259. Then summary trial is much simpler. The summary trial maximum punishment is 3 months. Okay. How much? 3 months is the summary trial. Okay. So it is from section 260 to 265 is the summary trial. Then last is plea bargaining. Okay. So section 265 to entire section 265 is plea bargaining. Okay. So you can expect questions from plea bargaining also. Just I'm seeing there is. I'm just opening that plea bargaining. So yeah, plea bargaining is section 265. Okay, what is plea bargaining is just basically it is a sort of compromise. Okay, the bargaining is that the accused will say that I am ready to plead guilty, some sort of thing. So the punishment will be reduced. Okay, it is negotiation between the accused and the prosecution, during which the accused agrees to plead guilty in exchange of certain concessions by the prosecution. So prosecution will not, they will go some little bit lenient. So here we are giving plead guilty, right? So plead guilty normally that is plea bargaining, which is under chapter plea bargaining. Just now I told, yeah, chapter 21A. Okay, so this is not for all cases. Okay, in few cases, plea bargaining is accepted. So this is basically in many cases where the punishment is less, say 3 months punishment, 2 months punishment, they may impose with fine and leave. Okay, they will say, okay, you agree, we will not give you punishment. Let us say drunken driving. Okay, drunken driving, they'll say, sir, I plead guilty, so punishment, you pay 5,000 and go. Instead of going to jail for 3 years. No, he want to contest. If he is convicted, then he has to go to jail for 15 days or 1 month. So to reduce the burden of the courts, mostly in less severe crimes, plea bargaining is done. Okay, I'm giving very simple example. In some crimes also, the punishment is reduced. Instead of 1 year, they will make it 2 months or 3 months. In some theft cases, sir, I am pleading guilty. Sir, I am sorry, I will not commit such things. Or beating wife, something like that, they will plead guilty. They will say, okay, you pay, or you will be sent, or you will stand in the court for the end of the day. In some cases, petty cases, they do that. Okay. So plead guilty or plea bargaining, that is the compromise between the prosecution and the accused to reduce the punishment or concessions in the by the prosecution will give some concession. Okay. So the person who want to plea bargain, he has to file an application in the court that he is bargaining with the file application for plea bargaining in the court, which offense is pending. Then the court, depending on the crime, they may agree. Then they may give the concession. Okay, but it should be voluntary. It should not be forced. Okay, they will ask whether he is pleading guilty voluntarily, and it is with force, without force. So it should be without any pressure or without any force. Then it will be accepted. So basically, it is done with to reduce the burden of the court for some petty cases. Okay. Then next is attend of person. So all other things are not so important. Okay. Judgment is another thing. So judgment appeals we'll talk in some other session. So we'll close the session. So we'll do another session for CrPC. So judgment appeals and balance also, we'll try to revise some important topics or any topic which you feel is confusing, because here up to 40 is concept based. After 41, all are bare act based only. Okay, plea bargaining also bare act based. But why I'm focusing on this, because you should understand what is plea bargaining, what are the steps in the criminal case. So it will be easy for you to understand. Proclamation also, if you don't know what is proclamation, then it will be difficult. After proclamation, all chapters till that section 155 or those are 154, they are not so important. Steps, criminal case step-by-step procedure starts from commission of crime, that is section 154 FIR onwards. Serious, again, important chapters, important sections for AIBE. Okay, and even for practicing also, this is very important flowchart. It is you can go through this. You can relate it with your bare act 154 onwards, and you can understand. It will be easy for you to understand what is someone's case, what is warrant case, when it is sessions case, when warrant is issued, when police can arrest. All those things are covered here in itself. Okay, cognizable, non-cognizable, bailable, non-bailable. If it is non-cognizable also, if it is non-bailable, then through court permission, they can arrest. Okay. Some cases, police themselves, then they can give bail. In some cases, they have to bring him to the magistrate for bail. Okay. Then when it is brought to the magistrate, then magistrate bail will be granted. Not by default, you have to file a petition, bail petition, then bail will be granted or rejected. So those things are, it will be clear for you if you go through this one. So all those things are part of the previous things 41 onwards, but I thought it will be easy when we are talking about when we related them to the case. Okay. So now for today, we'll stop the presentation here. If you are having any doubts, we'll try to answer.